Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to circle back on a case that we have talked about a couple of times before. It's a case that actually comes from my own backyard out here in Washington State. It's the case of Gators Custom Guns versus State of Washington. It is a challenge to Washington's magazine ban, which now sits on petition to the United States Supreme Court. We've covered the case all the way at the trial level. We covered the petition for certiorari, but today we're going to talk about an amicus brief that takes a very, very interesting angle, a very sarcastic, a very humorous, and yet very factually accurate angle, and it really does beg an excellent question. I think this is one of the most creative arguments I've ever seen when it comes to challenging the ridiculous nature of magazine bans. So today, let's go through it with you. So let's spend a few minutes and let's talk about Washington State's crazy magic bullet theory. Okay, America, we're going to talk about a case that is a challenge to a magazine ban. It currently sits on petition to the United States Supreme Court. It comes out of the state of Washington. It's a case that we lost at the Washington State Supreme Court by a vote of 7-2. The case is called Gators Custom Guns versus State of Washington. Now, I will acknowledge that the Duncan v. Bonta case probably sits in pole position, and if ever there was a magazine ban case that deserves to be accepted by the United States Supreme Court, it would in fact be the Duncan case. What we're going to focus on in the Gators Guns case, however, is a really good amicus brief in support of the petition that was filed by the good folks over at the National Association for Gun Rights, which means, yes, we're going to put a link down below for you to show them some love. I like it when I get to cover NAGR briefs because one of my absolute favorite brief writers in the world, Mr. Barry Arrington, is the author of this, which means the brief will be, in fact, brief, and it will also have a little bit of sarcasm and a little bit of dry humor, which, as you know, we here at Washington Gun Law are big fans of. So what we're going to talk about today, and I've called it the limitation du jour, but Barry has come up with a much better name, which is the magic bullet theory, which is this. If a 10-round magazine ban is constitutionally permissible under any of the theories of in common use for self-defense or more appropriate for military use or whatever other creative junk they come up with, what's to stop them from lowering it to 9 and then 8 and then 7? And then what happens when we're at 2-round magazines? Where does it stop? Okay, and so let me explain to you and let me show you how Mr. Arrington has framed this issue because it's really well done. Now, even though the Washington State Supreme Court did acknowledge that a detachable magazine is essential to the function of many semi-automatic handguns, and that the Second Amendment clearly protected all the ancillary rights necessary to exercise the core right itself, they were unable to reach the conclusion that the Second Amendment therefore covered detachable magazines. That leads Mr. Arrington to plead. Surprisingly, according to the court below, that conclusion does not follow. The lower court was able to reach this startling conclusion by invoking its magic bullet theory. Magic bullet theory, do tell. Under this theory, the plain text of the Constitution means one thing with respect to magazine X, which is covered, but something completely different with respect to magazine Y, which is not covered. The difference? Magazine Y has had an additional magic bullet added to its capacity. But which bullet is the magic one that transmogrifies a magazine from category covered by the text to the category not covered by the text? Is it the 3rd, the 5th, the 11th? What is it about that magic bullet that when it is added to the magazine, it becomes radically different from a magazine without it? When you think about it in those terms, and again, it is factually accurate, it's an excellent question, one that, well, we don't have to answer, but the state of Washington does. And as Mr. Arrington puts it, the lower court did not say. The court held that banning magazines with capacity greater than 10 rounds is permitted, but conspicuously, it did not say whether it is permissible for the state to lower that threshold. In summary, under the lower court's holding, there is a magic bullet, and citizens are also left to guess which bullet that is. And again, we've talked about this as the limitation du jour. If the court is willing to accept that, well, 10's a reasonable limit, and they haven't ever stated that, well, anything below that, now you're crossing the line, What's going to stop states like California, Washington, Illinois, New York, New Jersey, Massachusetts, all the usual suspects from just systematically lowering that threshold? To be sure, the court hinted, but did not actually hold, that the dividing line between covered by the text and not covered by the text is based on minimal functionality. It wrote that a firearm's purpose as a tool for realizing the core right of self-defense is fulfilled as long as it is still capable of firing. And it observed that this purpose can be achieved with magazines that have a capacity of 10 or fewer rounds. Does that mean that a state could literally limit magazine capacity to 1 round? Well, according to the Washington State Supreme Court, it appears so. And as Mr. Arrington points out, the obvious problem with this argument is that minimal functionality can also be achieved with magazines that have a capacity of 9 or fewer rounds, and 8 or fewer rounds, and 7 or fewer rounds, etc., all the way down to 2 or fewer rounds. Surely the Washington Supreme Court did not mean to imply that the state has the power to limit the capacity of semi-automatic firearms to 2 rounds. But that is exactly what the Washington State Supreme Court, that is exactly what the Ninth Circuit and the Seventh Circuit and numerous other courts in the land would do if given the opportunity, leaving the amicus party here to again point out, if minimum functionality is not the dividing line, then what is? Again, the lower court did not say, but unless the court announces a workable principle, it has done nothing but announce its gestalt. Here, the Washington Supreme Court has announced its gestalt. It says that 10 feels about right. However, it has provided no guidance on whether 9, 8, 7, 6, 5, 4, 3, 2, or perhaps even 1 would also feel right. And candidly, for many of these courts, other than an outright ban on the possession of firearms, nothing probably would feel right. The amicus party goes on to further plead, that is not a way to run a constitutional railroad, and this court should grant the petition, reverse the lower court, and apply actual principles of constitutional law to the issues raised by this case. Okay, it is the magic bullet theory, authored by Mr. Barry Arrington. The case, once again, is Gators Custom Guns, LLC versus State of Washington. We're going to link up NAGR's amicus brief down below. Links below for you to show them some love as well. Now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.